there are many different options that are there. When you are doing all these things, will your company proceed with the green card application? So that's the one that they have to be very careful about, that they need to discuss with the company. Will they allow those things? Will they continue with the green card if you are not working for the company? Then also, if the company is not willing to do, or even if the company is willing to do, you may want to spend some extra time outside the country. You may want to spend some extra time outside the country to gain extra time for you. For example, if your labor certification started in the early stages of the 4 years, and now it's going to take more than 2+ years for you to get the I-140 approval. Let's say, for example, you spend 4 to 5 months outside the country, though. You know that in the 6-year periods, any time period that you spend outside the country will not be counted towards the time. So you can extend the period of time, 6 years plus the time period, 4 months you spend outside the country. In that way, what will happen is that at a later time, you can reclaim that 4 months. In the meantime, you get the labor certification approval. So you can consider that. You can consider moving into H4. That's something that if you have an option, you can consider moving into B2 application. Now, in H4 and B2, be very careful. Will the company cooperate with you in obtaining the labor and I-140 approval when you're not working for that company? Very important though. Very important though. Then also there is options that even if you leave the country, the company can still get an I-140 approval, and then they can still file the H-1B and bring you back into the United States after the I-140's approval. But be careful with this option, because once you go to India, the company may say, yeah, I find another replacement. This fellow is also working fine. I don't need to bring that guy back. They can always feel that way. So all these options you need to consider if you are in the third year or fourth year of the H-1B unit. Fourth year of the H-1B, I'm sorry. In the fourth year of the H-1B, you need to consider all these options. Moving to H-4, B2, spending time outside the country. Will the company cooperate with you after you are not working for that company? Will they continue with the green card? Will they allow you to go to India or any other country and work for the company and continue with the green card? All these options you need to discuss with your HR. You need to have an idea. You need to discuss with the people who have had the labor and I-140 approval before in your company to see how the company is going to be working with you. In all these things, Nitya, what is more important is the company proceeding with the green card application thoroughly, even if the person is not working for that company, because there is a time period where this gentleman may not be able to work.
Sir, how easy or difficult is it, say, to, for people to just move to like either Canada or even South America to start working? Is that an option even for us?
That option is there, but will the company continue allowing them to have these people work outside the country? Now, to go to Canada or to go to any other country other than India, you need to have a work permit there.
Okay. Yeah.
So you need to have a work permit. For you to go to India, you don't need a work permit.
Right.
Can you work when you're in India, even though you completed your 6 years? Answer is yes. But the main issue, as I told you, Nitya Garu, is that will the company be cooperative? Will the company say, no, we're not? They may have some bureaucratic system involved in it. They can't just take the services of the people from India and pay them whichever way. I mean, there are ways to do it, but will the company be cooperative in those things? So that's more important. Yes, they can go to Canada. They can go to any of the countries in Belize, which is an English-speaking South American or Central American country. They can go to those countries and start working for those companies if they, but will the company allow? If the company allows, absolutely you can do so.
Got it. And how hard or easy is it to get a work permit in these other countries, Andy?
I am not that particular, Andy. I don't have much knowledge.
No, I'm just, yeah, okay. No.
I would rather say that it's easier than USA. That's for sure. I can tell. Anything is easier than USA. The bar is low for that. Oh.
The world is easier than the USA, yeah. But yeah, I hear you, sir. Thank you so much for that, sir. Anything else you'd like to add before we start taking our callers, Andy?
No, we can take the callers. Andy.
Okay, all right. Okay, let's take our first caller for the day. Okay, caller with number ending in 1016. 1016, we're ready for you now. Hello?
Hello?
Hello, sir.
Yeah, hi.
Hi, sir. Thank you for calling. Hi, sir.
Thank you for taking the call. Rahul, my question today is regarding 485 filing, adjustment of status. And I filed it in May 2023 to the Texas Service Center. And you know, when it was still current. And then July, as you know, it retrogressed. And then in October, it became current again. My date is March 2012. And what is happening of late since October and since it became current again is it's getting transferred multiple times between service centers. It went from Texas to NBC and then again from NBC back to Texas. And it's just going back and forth. And the last update I got from Emma was an interview waiver decision was made, like no need for an interview. But then it's still sitting in Texas. So I'm just wondering, like, at some point, does it need to go to a field office before it's actually adjudicated?
No, it can be adjudicated. It can be adjudicated by Texas Service Center. It can be adjudicated National Benefit Center. It doesn't have necessarily to go to the field office. So the only issue is that you filed the case, you filed the 485 in May of 2023. So since the final action date is current for you, is that right? You said, what is your priority date?
March 2012.
And you're in EB3, I'm assuming. EB3. Okay, so it's May 1st, 2012 right now. So you're current. Unfortunately, there is not much you can do. If you contact the ombudsman, congressman, they will just say that, hey, the processing time is delayed. You can't even go to the federal court to, hey, adjudicate my case faster because we only filed 6 months ago, 7 months ago. It has to pass more than at least 1 year for you to consider to go into court. Right now, I wouldn't do much because the more inquiries they do, sometimes what happens, you go and they have to pull the file out. It may take a little bit time to go back to the same position though. I wouldn't do much inquiries at this point of time. I would let it go.
Inquiry, you mean Emma inquiry or some other, like a
any other inquiries also. Okay. Try not to do Emma also because it won't help you right now.
Okay. So just sit and wait, basically.
Sit and wait. Yes, sit and wait. Yes.
Okay. And there's no trend or pattern where once a decision for an interview waiver is made that, like, you know, it's close to adjudication.
Yeah,
or something, or that...
it could be adjudicated soon. But as I said, the more you try to poke the file, I don't know if it's going to help. According to me, it harms though. So I wouldn't do anything. There is no set pattern that once the interview waiver has been done, you're going to get an approval in 1 month, 2 months, 3 months. We can't tell that. Okay?
Okay.
We'll go to the next person.
Thank you.
Thank you so much for calling, Andy. Sorry, folks, I was just having a little bit of a technical glitch. No matter. We will, before we take our next caller, Andy, I have a couple of questions. Rahul, I just wanted to also quickly touch base on like the lottery system and, you know, what's going to change and how, Andy, before we quickly get into our next segment of questions.
So the proposal, the proposed regulations, what they are proposed right now, which most probably will be implemented in the 2020, in March of 2024, which will be considered that as a 2025 fiscal year. So if, let's say, for example, Rahul Reddy has a job with Microsoft. Rahul Reddy has a job with 50 different companies. Let's say Rahul Reddy has 10 different companies. He's a, Stanford graduate and he is very highly prized. And he got 10 different offers from 10 different companies. And 10 different companies, if they file the H-1B though, they will only consider Rahul Reddy as one person.
Okay.
So when they pick the lottery though, they will go through all the people who have filed the H-1B lottery. Rahul Reddy is one. They will, even if 10 people filed the application, Rahul Reddy is only one. Then they will pick up the lottery system based on that. And if I get selected in the lottery, then I get to choose the company. If multiple companies filed, I get to choose the company that I want to go with the H-1B. So in this way though, we have seen, I know some companies that have filed 2,000 H-1Bs lottery though. That company has only 10 employees that filed 2,000 H-1B lotteries. Of course, they didn't file the H-1B application. That's a different issue. So what they did is that in the same guys that they filed 2,000 probably filed with multiple companies when there is no job offer at all. So to avoid the fraud, to not give any advantage in filing multiple applications by an individual. They have done this drafting, which they did very good in this. I think so. It's a good aspect that when you go in the lottery, you won't get an advantage. If I get filed with 10 different companies or one company, it's all the same. It won't give any advantage to the people.
Okay, then it sort of eliminates that multiple filings.
That's right. There is no incentive for the people to have a multiple filings.
Correct.
Normally we have seen some people who have jobs with Apple company, they filed with Apple, but then they went into all these fraudulent companies and filed the H-1Bs. Lottery, even they didn't have the job. So that doesn't give any advantage to them because you have Apple filing the H-1B application. So you have all these fraudulent filing, won't be any advantage. So the incentive is gone. So which is, I think so they came up with a very clever plan. We did suggested some things, but I don't know who suggested this plan to be. This was much better than what we have suggested though.
Okay. This is wonderful to hear, Andy, at least.
We suggested not to allow multiple applications, but that's not fair. What if the person has job with Microsoft and Apple? Both want to file the application. So now I get to select which one I want to choose. So which is actually a very smart thing they did.
Yeah. Doesn't matter the number of companies that are filing for you.
Right.
But what happens to the people who've had the existing multiple filings, and are they still going to pursue?
They are still pursuing. They are still revoking a lot of those H-1Bs. They're going after the companies. They are going after the individuals. We are still seeing a lot of revocations coming. H-1Bs that were approved previous years, this years that were approved in the multiple filing, we are seeing a lot of revocations. So definitely if anybody was involved in multiple filings, they should consult an immigration lawyer to see what are the plan B, plan C options. Plan B, sometimes what happens is that if you get knocked out in the United States with these multiple filings, they may bar you forever to come back into the United States for the fraudulent activity that you are involved in. So you may want to consider Canada option 2, just to be on a safer side. Now, people ask me the question, I didn't do any fraud. It's only the employer who did the fraud. So no, that's not how it works out though. We call it as a conspiracy to defraud. Let's say, Nitya Garu, all you are going to do is, I'm going to rob the bank, okay? You will just drive the car. You wait in the car outside, okay? Keep the door open, keep the engine on and everything. As soon as I come from there, okay? I rob the bank and I come from there, you just take me out. So now you're not going to be just charged for speeding ticket because you went on 100 miles per hour at the speed at the place of 35 miles per hour. No, that's not the charge that they're going to charge you. What they're going to be charged is because when we both agreed, when you knew that the purpose for which I went in the bank was to rob the bank and you cooperated with me, it's called conspiracy. So once we conspire to both the things, any crime which is in pursuit of that thing, of what the things are, so that you will be charged too. Even though, for example, you clearly instructed to me and I told you very clearly, I'm not going to kill anybody when I rob the bank. Okay? I took the gun there, but of course, something happened. I killed the person there. You will be charged with murder, even though we agreed not to, because it's part of, when you go to rob the bank, it can happen. Okay? Now, here, when you know there is no job, you have given your details to this particular company. The company has used your information to file the multiple application. You are guilty of the conspiracy there in filing the fraudulent application. Now, will they come after? Will the police come and arrest? Will the ICE is going to come and arrest these people? Most probably not. Most probably not. It's only the USCIS that is going to issue the notice of intent to revoke and revoke it, and the consulate normally is the one which is issuing the misrepresentation, saying that you did cooperate with this individual and then you are barred to ever come into the United States because you have conspired to defraud immigration in obtaining the immigration benefits. That's the acquisition they are making, and that is a very big thing that's going on for those people who have done multiple filings.
No, yeah, that makes sense, Andy, because I mean, like you said, even if the person driving the car doesn't know that you're actually going to steal from a bank, it's
no. If you know that I'm going to just withdraw the money, okay, and if you know that I'm going to just withdraw the money and then I steal the bank, you're not liable for it.
Right. Okay.
Because if I'm just going, I'm going with a check, I'm going to withdraw the money, that's fine. But if I'm going to take a gun, I'm going to rob the bank, then you are guilty.
Okay,
Now,
okay.
in this case though, if they know it's only withdrawal, they will not be guilty. So the question is that, was there a job for this particular person at that point of time? Was there an interview? Was there an end client? Where is the job? If you know it, all those things, then it's probably is a different issue. But you have rightfully said some things, Nitya Garu, that I want to elaborate the things though.
Okay.
There are some people that we know of where they have given the information. They are working with a company called ABC Consulting Inc.
Mm-hmm.
So Nitya Garu is working with ABC Consulting Inc. You have given your passport, education, every details to file the H-1B with ABC Consulting Company Inc. So that's more like withdrawal of the money in the bank.
Right.
What ABC Consulting Company did is that they passed your information to XYZ and there is companies like X, Y, Z, VW, whatever, all those companies, they filed with 10 companies, but you didn't know about it.
Got it.
Then you are right. Then this person should not be punished for robbing the bank. Because as far as your knowledge is concerned, I'm only going to withdraw the money.
Correct.
When withdrawal means you think I'll take a check, go to bank and withdraw, not take a gun and withdraw the money. Is that right?
Right.
You didn't know that. So here is where the problem is coming. When you don't know the things though, sometimes what happens, because you're associated with me, Nitya Garu, when I went into bank, I robbed, which you didn't know I was robbing the bank.
Mm-hmm.
They may initially consider you for actually bank robbery. It becomes a lot of burdensome right now for you to prove otherwise. I didn't know Rahul is going to rob the bank. I only know that. So that is happening with a lot of people too. That's the reason why I'm telling these people to consult an immigration lawyer. So what strategy we are doing in this case, Nitya Garu, when this particular individual is not involved, have no knowledge of multiple filings, we are telling to complain to the Department of USCIS, the ICE, report to them that this company has committed fraud. I was not aware of it. So in our case, let's say, for example, you know that I'm only withdrawing the money and I went and withdrew the money different way, okay, with a gun and withdrew. And we ran away. And then you later on came to know about it, that I robbed the bank. What is your first thing that you need to do when you're not involved in it? You need to report to the police.
Got it.
Then it will become easier for you to deal with. If you took the money, not only that, you took a share of that money, then it's not fair for you.
Trouble, yeah.
So what we are telling these individuals who are not involved in the fraud is complain against the company. So tomorrow, if the USCIS or the consulate is going to accuse you of it, we have a copy of the complaint that you made to the USCIS, and this may save you. I'm not telling this will save you, but this has a very good chance for us to save you. So in our case, I robbed the bank. You didn't know that. Now you knew it. You complained to the police. Rahul robbed the bank. Here it is, the money, and here is where Rahul is.
Correct.
Then you will have a good chance of getting out of that. But if you just keep it calm, then it will be hard for you later on to get out of this. And that's the reason why I tell people, if multiple filings are involved, consult a lawyer.
Thank you, Rahul Garu. All right, on that note, let's take our next caller.
Which bank we're robbing?
You only have to tell me which bank has the money nowadays. Hello, caller with number ending in 2280. We're ready for you now. Hello?
Yes, ma'am.
Hi, sir.
Yes. Hi, Nitya Garu. Hi, how are you?
Sir. Yeah, I'm good. Go ahead, sir, with your question.
Hello, Rahul sir and Nitya Garu. You guys are doing amazing job. I got two questions. The first one is, I'm currently on J1 visa, and I got a sponsorship for O1 visa from a company, and they are going to process the visa. So my question is, if I got an approval for O1 visa, does the start date of the O1 visa will be the approval date or the date which we intended, like we listed on the petition, like some date which I want to join in the
you
company?
said, do you have a 2 years home residency requirement on the J visa?
Yes, sir. But I got the waiver.
Sounds good. The O1 visa, let's say, for example, you filed the O1 visa in November 27th, okay? Normally, we can put November 27th start date. But can you start working on November 27th? No, you can't because O1 is not approved. Yeah. So let's say that your O1 visa is approved on December 5th, though. The start date on that one will be December 5th. Okay? Irrespective of, you cannot start working until December 5th on O1. You have to wait until the O1 is approved. Okay. Now, there are some instances where we put the date as, let's say, for example, in March of 2024. Okay? We put the start date of March of 2024. So if it's approved on December 5th, can you start working on December 5th? No, because we put the start date as March 25th. So if they have put the current date, and they're approved, you can start working immediately. But if they put the future date, let's say March 25th of 2024, if they approve on December 5th, you have to wait until March 25th to work. Okay?
Awesome, sir. That sounds good. Really good. Yeah. My second question is, I have a approved I-140 in EB1. So can O3 dependent, my wife is eligible to apply for EAD, like H4 EAD?
No, O3 doesn't get EAD. No, you don't. It's only H4 and L visas. O3s don't. Okay? But if you're
although I have I-140?
You told me that. Yeah, you told me that. They are not eligible for it. Okay?
Okay.
Now, one caveat though. The O visa people, even though it's not a dual intent visa though, the immigration is very liberal in implementing that dual intent on O visas particularly though. So they're very liberal. We haven't seen any denials of the O visa because you have an I-140 approval. Okay, I just want to let you know on that. Next person. Okay.
Thank you, sir. Thank you very much. It's really helpful.
Thank you for calling, sir. All right. Before we take our next caller, Randy, we have a question. This is from PK Rancho. Says F3291 is referred to as Senate Judiciary Committee on 11/13. Any news about the bill being reviewed this year?
This year is very unlikely. If it has to be passed by 2024 December, somewhere by that time, because just because it's referred to the Judiciary Committee doesn't mean that it's going to be. It will go through the Judiciary Committee. It has to get approved in the Judiciary Committee. And when it is in the Judiciary Committee, there will be comments and there will be some amendments done in the Judiciary Committee sometimes, and then it will go to the Senate. At the same time, when it is being considered in the Judiciary Committee, though, they may refer some people in the House of from the Congress, from the House. They may do a parallel bill very similar to this one, and they may get this thing going on in the House Judiciary Committee. So once the House Judiciary Committee and Senate Judiciary Committee approves it, then it goes to the full House. Once it goes to the full House, both of these things should be approved. Then if there is any differences, the committees will just adjust the differences and then it will go back to the Senate and go back to the House and it get passed in the House and Senate, then it goes to the President. So the entire process will take definitely, I would say that at least until June or July of 2024, I would say by that time. The good part, Nitya Garu, I know last week Emily has covered a lot of this on this topic, why we should encourage people to work on this one, why people should not be discouraged is that every year we have made progress on this one. Of course, we did not win, okay? We came very close to win every time and we did lose. Now, we only need to win one time, guys. We may lose 20 times. Okay, this is a soccer match that ends like this. they can keep on hitting goals on us. They can hit 20 goals on us. But the time we hit one goal, okay, on them, that is this. The game is going to be stopped and we won the game.
Right.
So we need to do that. For that, we need to work hard. Of course, they have put 20 goals on us. We are still losing. Definitely, we need to fight back. We need to put that one goal. And for that, we need your cooperation. We need all of you. Yes, it has to go through all these things. I'm expecting it somewhere in June or July, some moment. The good part is that this bill, which wants to kind of remove totally the per country limit, actually started in the Senate. Why is Senate more important is immigration bills in general should originate from Senate. That's a tradition though. Now, any finance bill should originally originate from the House. That's the tradition though. So they're following the tradition right now. Hopefully this will go. Now we need 60 votes to pass this bill in the Senate. We have enough votes in the House. There's no doubt we have enough votes in the House.
Exactly, yeah.
Yeah.
So that now that the Senate itself is bringing this up, there is a better
Yeah,
chance that
there's a better chance. Yeah, they might go through. Yeah.
Got it. Thank you, sir. Let's take our next caller.
Following the tradition right now.
Perfect. Caller with number ending in 3757. 3757. We're ready for you now. Hello.
Yeah, hello, Nitya garu.
Hi, sir. Thank you for calling, sir. Please go
Hello,
ahead.
Yeah, hi Nitya garu. Hi Rahul. So thanks for taking my call. So this is, okay. We did go for H1 extension in April and got approval. And following approval, so I had a site visit. And when USCIS officer came in, so he did talk to my manager first and then talk to me. We thought all went well and yeah. But a few days back, we got a notice of intent to revoke, saying that they are saying that base level designation is inconsistent with the position. They have clearly mentioned this position requires advanced skills and 5 to 10 years of experience. But your current LCA says wage level 2. So they are questioning wage level. My question here, sir, my employer says, let's go ahead and file amendment with wage level 4. And we didn't answer yet. We are going to answer now. Notice of intent to revoke.
Is this your first H-1B?
No. This is, I had several H1s. This is the first time I had site visit.
Got the point.
And my question, sir, actually, so he is saying that we are going to file amendment with base level 4. And later on, let's say example, we will file in premium processing, it gets approved. So down the line, few months, what happens, if Nair, even though we answer notice of intent to revoke, if that H1 gets revoked, will that amendment H-1B will be valid?
No, because base H-1B has gone though. The amendment H-1B will also be considered to have been voided though. What can be done here is that, I would rather want to answer this, definitely answer this one. If you want to stay on the safer side though, you may want to move to a different company than this company. You see my point?
That is what I'm thinking, changing the employer, yeah.
Employer changing would be an ideal issue though. Now, irrespective of, is this issue going to harm you in the long-term future, assuming that they revoke the H-1B? You won't have any long-term negative effects of this one though. It's only temporarily to get on the H-1B to a different company. Maybe you may have to go to India to get the H-1B stamping. At the most, that will be the consequences, but the long-term effect will not be there for you. Negative effect.
Okay, Rahul, actually one more thing. Yeah, and I got that point. Okay, let's say example, if I change the employer and, if I get H1 with I-94, because I already had expired visa on my passport, can I go to Mexico with automatic revalidation? Will that work?
Why do you need to do automatic revalidation when you have an I-94?
Because you see, if I get a H1 transfer with a I-94.
I-94,
so,
yes.
I mean, yeah. So if I go to Mexico, I thought, we don't need to go for visa stamping.
Why are you going to Mexico?
Oh, okay. That is not. You're saying that it is not required because no, I thought you said it will be long term. It will be records will not be clear, right? So to make all the records clear,
you can always. I got the point. You need to clear the records. We consider that if there is anything that happens, it's considered to be a status violation, though. Okay, status violation. Let's say, for example, they say that. No, it should have been a wage level 4, but you are in wage level 2, that you did, they revoked the entire H-1B. So it's a status violation. Once it's a status violation, how many months did you violate the status? If it's more than 6 months, you're not eligible for the green card. Ooh, it's a big deal. No, because remember, whenever you go outside the country, you come back in, they should only, in the 485 application, in the adjustment of application, of the green card application, they should only look into the status violation since your last entry into the United States to the time you file the 485 application. You don't have to cure it right now. You're not filing the 485 right now. You need to cure it before you file the 485.
No, actually, mine is very clear. We are very near, actually. So mine is August 2012, prior to date.
Did you file the 485?
No, not actually. We missed actually. At the time, I changed the employer. I didn't have
Then definitely, I will do the Margarita search. I will do the Margarita search.
Yeah, that's what I just wanted to. Okay, that's what I wanted to know. So I mean, amendment is not advisable, right? So changing the employer is advisable.
Changing the employer would be, but then what about the green card though? Where is your labor certification with?
He is my current employer only, but I hope he will support me.
And I got the point, but I want you to definitely consult a lawyer because something is going wrong with you. It's been 2012 August. It's been current from 2020 October. Where are you sleeping? Somewhere something is wrong.
No, actually, mine is I changed the employer at that time. Before COVID, I didn't know that.
Even if you change the employer, it takes only 2 years for you to get the labor certification approval, and there are still shorter forms of getting. We are in 2023 November. Anyway,
actually, recently,
let's not get into
2 days back only, my PERM got approved. So
definitely, you may want to consider staying with this company though, because you may want to stay with this company. Even if you move to a different company, you can still come back to this company again. So you definitely may want to strategize this one. Okay? But yeah, I agree with you. Changing company would be better.
No, he is saying that, my attorney is saying that, so let's go for an amendment, and then once you get approved,
I don't agree with that idea though.
He is saying that go for stamping and then come back. That's what he is saying.
No, not with an amendment, but filing an H-1B is a different issue than amendment. He can file a H-1B with the consular processing.
Yeah.
Okay.
Okay. So, yeah. Thank you, Rahul.
Thank you.
Thank you, sir. Thank you so much for coming.
Bye.
Appreciate it.
Nitigar, I want to elaborate what I said, and he got the point of going to Mexico very good, because if there is any status violation by going to Mexico, it's like dipping in the Ganga and coming back. That's Margarita switch, we call it as. He got this one. His strategies are good, but somewhere he's neglecting his green card application. His prior date has been current for 2020. Yeah, we'll go to the next question, Andy.
All right. Yes, sir. Thank you. Let's take our next caller, Andy. Let's take our next caller. Okay, caller with number ending in 1795. 1795, we ready for you now? Hello?
Hello, hi, good evening.
Hi, ma'am. Thank you for
Can
calling.
you guys hear me? Yes.
Go ahead, ma'am.
I just had a quick question. So I applied for my PERM in November 2022 and I'm still waiting approval, even though the DOL bulletin says December 2022 is in progress. So I'm just like, I'm not sure. I talked to my employer. He said we should still be good. There are a couple of, pending applications, and mine falls in the Dallas region.
I agree with your employer. We have some cases that we filed in November that are still pending. I will not do any inquiry at this point of time. I will wait for at least 1.5 months before we see a trend that the November cases are cleared up. Right now, I can tell that all November cases are not yet clear. Even though they publish it, the government lies online, saying they report wrongly. Okay, believe me on this. So I would not do anything at this point of time. They are right.
Okay, sounds good. That was my question. I just wanted to check, considering I'm almost past 365 days.
I understand, ma'am. I understand. You're eligible for 1 year extension if you want to. You're eligible for 1 year H-1B extension.
Can I do it now, or do I need to wait for 6 months?
When is your H-1B expiring?
2025 Jan.
No, I wouldn't do anything. Why would you do? I would not do 1 year extension right now. No, absolutely not. I would wait for the I-140 approval, and then later on when the time comes in, I will do the 3 years extension. But let's say, for example, if your H-1B is expiring in December of 2023, though, I would file a H-1B extension for 1 year for you. Okay? But that's not the case.
So technically, yes. So technically my H-1 expires in October 2024, but I added the 3 months that have stayed outside the country.
Got it.
So that's where I arrived at the Jan 2025.
Sounds good. Sounds good. That's good. That's good. So you're in no hurry right now to file the H-1B extension. I completely agree with your company on that. There are cases in November. I would not do anything. And if by any chance you don't get the labor certification approval by, let's say, January of 2024, please come to the to TVASIA. Okay? Thank you.
Sure, sounds good. Thank you so much.
Thank you, ma'am. Thank you so much for calling, Andy.
This is exactly our topic was, Nitya Garu, that how long it's taking for the labor certification. The prevailing wage for her took 8 months, and then the advertisement period, then this one. And people, and she's a very prudent lady. She's acted very good. And she's been our customer. That's even better. She's been listening to us. So that's good. I want people to listen to us. That's the best thing that we can do.
Okay, awesome, Andy. Thank you, sir. Let's take our next caller. 1 second. Okay, caller with number ending in 1352. 1352, we're ready for you now. Hello?
Yeah,
Hi, sir. Thank you for calling, sir. Please go ahead with your question.
Yeah, I have a question like, can we apply I-140 for H-4 EAD?
Can we apply EAD along with the I-140?
No, like, can we do the I-140 green card processing for H-4 EAD?
Oh, okay. So you mean to say for those people who are on the H-4 EAD, can a company file a labor and I-140 for them?
Yes.
Absolutely, yes. There is no requirement that the person has to be an L1 or H1 to file the labor certification. The person can be an H-4 EAD to file the labor certification and I-140. Absolutely can be done.
Yeah, I checked with my attorney. They are saying, like, do we need a EAD card to get the process started, or like without a EAD card, can we start the green card processing?
The green card process can be started even if the person is an H-4 and not an EAD. Just a basic H-4 also They can. But will they do it or not is a different issue. Will they do it or not is a different issue. But can they do it legally? Absolutely they can.
Yeah, another question, Rahul, like is E3 a best option than waiting for a green card, like to go to Australia and become a citizen and come back on E3 visa? It's like better than waiting for the green card. Like my priority date is 2018.
Well, so definitely considering the Australian green citizenship, though, it's a personal choice. Yes. There's nothing wrong in it. I personally myself would have choose Canada or Australia instead of dealing with Rahul Reddy for such a long period of time, or people like him. Definitely, I would choose. That's your personal option. But you don't need to come on E3 visa, though. E3 visa, well, there are a couple of, they are eligible for E3 though. Australian citizens are eligible for E3, they are. But there are a couple of problems, a couple of things that I want you to note. Why did we choose E3 over H-1B? Because we have to go through the lottery system. H-1B is a lottery system. You file in March. You don't know whether you're going to get it. Even if you're going to get it, it's going to be like October, is that right? But in your case, you told me your H-1B is already approved, I'm assuming, because your wife is an H-4.
Yes.
And you told me your I-140 is approved. So you can come back on H-1B. So you can go to Australia, you can become an Australian citizen, and come back on H-1B again, not going through the lottery system.
Yeah, okay, Rahul. And one more question, like,
and let me tell you another. Let me tell you another problem.
Okay.
Let me tell you another problem. E-visa must have an intent of non-immigrant intent only. They don't have a permanent. They can't have a permanent intent of settling in the United States. You have an I-140 approval, so that becomes a problem for you too. So either way, E-visa is not good. Whether you want to go to Canada, Australia and become a citizen, that's probably is an option you should consider very seriously. And then come back again anytime on H-1B. But anyway, I interrupted you. Go ahead with your question.
Yeah, and the question is, like, my employer is filing for H-1B extension, even though I have H-1B validity until 2025. Along with my amendment, he is filing for 1 more year extension for my H-1B. Is it?
Why is he doing?
Okay?
Because he wants to get it. Oh, he's filing an amendment for
1 more year.
Filing
along with my amendment, he is applying for my H-1B.
Why is he filing an? Why is he filing an amendment?
Like I recently got a new project, so change of client is there.
Got it. Okay, sounds good. So it's absolutely good thing that he is doing. When I'm filing an amendment, why would I not click and one thing amendment plus extension? Absolutely, I would like to do it. I do not, if you have until 2025 like, and if I can get into 2026, I will. And they're doing very good job.
And my wife is in India, and can they apply for H4 EAD for the new H1B extension?
No, she has to be in United States when she is applying for the H4 plus EAD.
Okay.
But she has EAD until 2025, is that right?
Yeah, recently we applied like 4 months back. We are still waiting on the
so she's going to get an EAD until 2025. So she's going to get until 2025 with that one. And then once she comes here, she can apply for the EAD until 2026. So there is no hurry for you. I mean, if she's here, she's going to get the EAD along with the H-1B. If not, she will not. Okay?
Yeah. Okay, Rahul. Thank you so much, Rahul.
Thank you very much for coming in, sir.
Bye.
Thank you, sir. Thank you so much for calling. All right, let's take our next caller. Okay, caller with number ending in 2851. 2851, we ready for you now? Hello? Caller with number ending in 2851. We ready for you? Hello? All right, let's try this caller again later. Let's take another caller, please. Okay, caller with number ending in 9371. 9371, we're ready for you now. Hello?
Hello.
Hello, sir?
Yeah, hello. Can you hear me?
Sir. Yes, sir. Thank you for calling, sir. Please go ahead with your question.
Yeah, hello. Hello, Rahul Garu. So my father had an H-1B back 10 years ago. So now I'm planning to apply for B2 visa. So are there any necessary steps do I need to take?
No, none. If he had a H-1B before, had worked in United States and he left the country and he is there, nothing, no necessary. In the DS-160 form, they will ask the question, have you ever been in USA? Those simple questions, no extra precautions need to be taken. Did he ever apply for the I-140?
No, sir, he didn't apply for I-140, but recently, like when we saw about those I-94 days, we just came to know that he stayed extra 7 days. So will that be any problem?
No, just because of 7 days, it won't cause any problem. None.
Yeah.
Okay.
Thank you, sir. That's my only question. Yeah, thank you so much.
Thank you, sir. Yeah. Thank you for calling. That was a short and sweet call. We like it all like that. All right. On to the next call.
Nitya, we are the only persons in the, I've looked into the TVASIA is the only thing where we have interactive people calling us, not just ask the question. Sometimes we have to do interact. A lot of those things are just answering the questions of what they are, but not interacting.
Right, right, absolutely.
Go
And
with the
we
next.
always encourage people to keep calling us and bringing us more interactions and bringing us more challenging questions as well. We'll only be happy to answer them. All right, on to the next caller. Caller with number ending in 2621. 2621, we're ready for you now. Hello? Caller with number ending in 2621. We're ready for you. Hello? Okay, let's try another caller and we'll come back to this one. Okay, caller with number ending in 6776. 6776, we're ready for you now. Hello? Caller with number ending in 6776. Hello? Oh, I think we lost the caller. Okay, let's try another one, Andy. Okay, let's try another caller. Okay. We'll come back to this one. Caller with number ending in 1242. 1242, we're ready for you now. Hello? Caller with number ending in 1242. Hello? Hello, sir. Can you hear us?
Yeah, I can hear you. Can you hear me?
Okay, sir. Yes, sir. Thank you for calling us. Please go ahead with your question, sir.
Yeah. Hi, Nitya Garu. Hi, Rahul Garu.
Hi. Hi. Go
Yeah,
ahead.
I have a question, Rahul Garu. Yeah. Hello. Hi. Good evening.
Yeah.
Hi, Rahul Garu.
Go ahead with the
good
question,
evening.
sir.
My question is related to I-485. I think you are dealing with H-1B, but I have an irrelevant question related to I-485 because I was trying to connect to many times, but I was not able to connect to. I applied for EB1A category and my I-140 got approved. And
When was it
after
approved?
that, I
When
filed
was
my...
it approved?
Yeah,
when was it approved?
It was approved sometime in April 2023. Okay. And then I applied my EB1 I-485 in May 17, 2023. Okay. So after applying my I-485,
when you applied 485 May of 2023, the priority date is current. At least the filing date is current.
Yes, exactly,
Okay,
exactly. My priority date was correct. So then what happened? So because I applied for I-485, I thought of going to Niagara Falls from Cleveland, Ohio. So I went to Niagara Falls, but unfortunately my GPS routed me to go to the Peace Bridge that is connecting to Canada. Okay. Okay. What happened? I know that it is going to Canada. Then I stopped right there. And then I did not cross the border, or I did not enter the Peace Bridge, but I stopped my car and then spoke to one of the CBP officer, Customs and Border Protection officer. He told me to just take U-turn before entering the Peace Bridge and go through one of the counter, he said. So I just, as the CBP officer suggested, I just took the U-turn and then went to one of the inspection counter. There he asked me some questions, identification questions and passport and everything. I showed him everything. And I entered inside also, office also. So they also asked some questions, and then we particularly asked the officer, did I cross the border? Does it come to crossing the border? They said, no, you never crossed the border.
But anyway, okay, why are you asking this question?
Yeah, because in September 25th, what happened? So they stated that my GC was denied because I departed and left the United States on June 3, 2023. That is incident happened on June 3, 2023. But I never left and departed and left the United States.
Why is the GC denied? Which visa you were in?
I was in O1 visa, not in H-1B. That's the problem.
Wow.
Yeah, O1A.
When
that
was
time I
it
do not
denied?
have advanced parallel 2. I do not have advanced parallel 2.
I got the point.
Yeah.
I got the point. When was it denied?
It's on September 25th, 2023.
Did you file a motion to reconsider?
Yeah, I-290B I filed with an affidavit and with all evidences and then maps and everything I provided.
It's going to be up to the discretion of the officer at this point of time to revise because here is the thing. Do you see in the movies they put a line, you cross the line, is that right? Now you cross the line.
Yes. Yeah.
So there is the bridge, you didn't cross the bridge though, but you went onto the bridge.
No, I didn't. I did not even enter the bridge.
But we don't.
I did not even enter the bridge.
Yeah, I don't know where the line is. So
line is so far. Yeah, I know.
Which
borderline.
Which
so
line?
Far.
That borderline it's very. I don't know. I have to practically, if I were your lawyer though, I will tell you to pay me the money to fly there and then take a video recording and see where the line is, and then probably would have responded to the motion to reopen. I mean, because I don't know exactly.
Yeah, that's what I have seen in the maps. I have seen in the maps.
No, I will
Google Maps.
Because
I have seen the border.
Right now, I am not there in the peace bridge right now. So it's very hard for me to judge, did you cross the border, did you not cross the border? So you might have, you have done affidavit and you did all the things, but it will be up to the discretion of the officer. But I have to look into how the motion to reconsider was being filed to see what are the merits in that case. But anyway, what is your question now?
So my question is that, can I ask a CBP officer to investigate that issue, because I have all the evidence, video footage and everything they might be having. So that shows that I did not cross. Can I request my employer to contact CBP and to get all those information? And
they won't. They won't.
So but what happens? So my I-94, there is no departure record. I spoke to CBP office. They said they do not have any record.
I got the point, but here's the thing.
Yeah.
Well, you went through you were at the border post. Period. Once you're at the border post, USCIS get the information. Okay. Whether or not it's online reflecting or not is a different issue. Now, the only fight that you're going to do right now is that first argument I would make is that you never departed. Second thing is that even if you departed, that was not a meaningful departure. These are the two arguments I will make, but you already might have made that argument right now.
Yeah, I already made those 2 points very clearly.
So right now you just have to wait for them to decide.
Okay.
I don't have anything. I don't have anything else in my thing that I can tell you. Okay.
So what I'm trying to say is, there any way I can request congressional inquiry to get the report and then send it to USCIS?
You can try. They won't.
Like senator.
You can try, but they won't. My knowledge is they won't.
Okay. Thank you so much, Rahul Garu. Appreciate it. Yeah, thank you.
Rahul, for this gentleman, does it make sense to reach out and have a bigger consultation with an immigration
No, it doesn't. It doesn't, because he already has an immigration lawyer that has considered. He has written the affidavits and they already respond to the motion. There is nothing there a different immigration lawyer can do. And I would, if I were him, his lawyer though, I would ask him to pay me the money to go all the way to the peace bridge and exactly walk through the steps, because he can still walk through those steps and come back. Is that right? I mean, there is no harm for him. So I would that's the only thing. But otherwise, he did all the steps. By consulting an immigration lawyer, I don't think so he's going to be any better right now. Motion to reconsider has already been filed.
Got it. Okay. Cool. Thank you, sir. Let's take our next caller, Andy. Okay, caller with number ending in 1243. 1243, we're ready for you now. Hello?
Yeah, hi Nitya Garu. Hi Rahul sir, how are you?
Sir, thank you for calling, sir. Please go ahead with your question.
Yeah, hi Rahul Garu. Actually, I'm on EB1 2015 priority date. My 485 was filed in July. And last week I got the medical RFE. I responded to it. My family's 485 was filed in October. So I just want to know, if I get my GC first, what will happen to my wife and daughter? I'm on H-1B right now, and I'm a Canadian citizen.
They are here in United States, is right? Your wife and daughter?
Yes, sir. They are with me here.
You filed the 485 for them too, is that right?
Yes, sir.
Okay, if you're in H-1B, let's assume that they're in H-4. They will not be in H-4 anymore. They will be on adjustment of status. they can stay in United States. And once they get the EAD or advanced parole, they can start working and traveling too. So even they may not approve your wife and daughter with you, but that's fine. It's not a big deal. They will be in adjustment of status. They can get the green card eventually.
Okay. So typically, do you see any delays
We can't tell right now. I just saw an email of one of the EB1 case we filed in June of 2023. They've just approved the green card. June of 2023, they approved the green card. So yeah, it could be possible they can approve the green card since they have issued a medical RFE, which is actually very good for you. But when did you file for it? I know you filed for your wife and child in October. When did you file for you?
Mine was in July, so July 2023.
Yeah, they may. I mean, RFE for medical is a good sign, but there is nothing much you can do right now. You just have to wait. Okay? Don't poke, don't call them.
So thank you so much.
Chat with Emma, don't do anything. Better, because they issued an RFE, you send a response, everything is going good. Because when you poke, they may pull the file out from there. So don't do anything right now. Okay?
Okay, so thank you for everything you do for the community. Thank you so much. Have a good one.
Thank you.
So thank you for calling us. All right, let's take our next caller.
Couple of notations on the previous, not this caller, the previous caller, Nithya Garu. I have seen this mistake so many times. People just cross the border. I don't know why they don't say that you are leaving United States. They don't put any board like that. It's just, you don't know you're crossing the border. You're just going on a highway. There is nothing there. You just go to Mexico. That happens. Coming to this other caller, the just got a caller, we are seeing a lot of trend when I see a lot of questions coming out on the chat where people are asking questions. Why can't you predict the priority date? So why can't we predict is that the reason is that people like this gentleman who was a 2015 EB1 category, I don't think so he filed EB1 in 2015 and waiting for all this time. He most probably was an EB2 or EB3 and converted into EB1, either EB1A or EB1C, I don't know. But these are the people that are coming out from out of the line and coming into the line somewhere. So it's very hard to predict because of these people. Why can't I predict EB1 movement? Because of the people who are previously in EB2 and EB3 are moving into EB1. It's not going in a straight line. They're cutting the line.
I mean, if USCIS itself can't predict much of anything.
Right. USCIS cannot predict. We cannot predict. How do we know that?
How do we know when what's happening?
So when you're in line, is right. There are 10 people ahead of it. Okay.
Yes.
So now I'm supposed to be the next after 10 is right. But then people are cutting the line from EB2. They're coming into this line. Then it becomes weird. How do we know when? It's very hard to predict when the EB2 people are going to come and cut the line. So it's very hard.
Yep. I think from our segment going forward, I'm going to have a section with a parrot.
That's better. Yeah, we need to have a parrot with us.
Take your question and then it will say yes or no. Will I get my green card soon? Yes or no, So that's what we're going to do because
it's hard to predict. It's hard to predict.
He's definitely in a different profession. So we'll get someone who's an expert at predicting and then we'll have them do that, which is like the parrot. Okay. Call our number ending in 7363. 7363. We're ready for you now. Hello?
Hello, Nithya Garu and Rahul Garu. So,
hi, sir. Thank you for calling, sir. Okay, sir.
So I have a very basic question regarding H4 extension and H4 EAD. So actually, I moved to the US around August. I was been in the US, going to India to multiple times. But recently I got married and then my spouse arrived last Monday.
Congrats.
2 years. So my employer filed my extension, H1 extension, and they were saying that by using that receipt notice, I can file an H4 extension for my wife. So I got the receipt notice, okay, the one which my employer had filed, and now I'm looking at the information on how to file the I-539 form and I-765 and all, right? So is it, do I really need to go with the attorney or can I do it by myself? That is,
I would recommend going with a lawyer. I would recommend going with a lawyer. Your company has already hired, go with them.
Okay.
Okay? Okay.
No,
But
no,
yeah,
no,
you don't
my
need
company is not.
Yeah,
My
I would
company is
recommend go with
not.
it. I would recommend going
Okay.
with a lawyer. And yeah, you don't need an
Okay.
approval to file for H4 plus EAD. You don't need an approval. Just a receipt notice is good enough.
Okay.
Okay?
Okay. Yeah. Okay. Sure. Yeah. Thank you so much.
All right. Thank you, sir. Thank you so much for calling. Let's take our next caller. Okay. Caller with number ending in 8777. 8777, we're ready for you now. Hello?
Hello?
Hello, sir?
Yeah, can you hear me?
Yes, sir. We can hear you, sir. Thank you for calling. Please go ahead with your question.
Yeah, Rahul Garu. So my question is regarding to the B1 visa. I actually applied the B1 extension for my in-laws when their COVID time. And they actually extended, they stayed here on more than 1 more month after the 6 months, and they went back. And I got the receipt notice only after they left home country. So I didn't, then after 2 months, I got some letter for the biometric process. But since they're not here, so I didn't process, I didn't follow up that after that. So my question right now is that if they can come back right now without any issue, or I need to do something else?
You requested for 6 months extension, but they stayed 1 month after that. So let's say you requested an extension until January of 2021. They stayed until February of 2021 and then left the country.
Yes.
If that is the case though, then technically speaking about, you cannot, the passport visa is invalid. The reason is that if you stay 1 day over the period that has been authorized for you in United States, the passport visa, even if it's valid for 10 years, becomes invalid. They have to apply for the visa again in the consulate and then they have to come. Don't let them come directly because they may be deported.
Oh, okay.
Okay?
Okay.
Okay then.
So okay, so I think no, I think I may getting confused or not. I don't know. They came here and stayed 6 months. So that's a valid period. And for extension, because of the COVID time, they couldn't able to travel back. I applied for the extension, and they left after 1 month after I applied extension. But I didn't get a receipt notice in that 1 month period. And
wait. So let's say they came in January of 2020. Their authorized stay was until June of 2020. You applied for the extension from June of 2020 to December of 2020. Did they left in July of 2020 or January of 2021? July of 2020.
July 2020.
So you applied extension until December of 2020 then? Because if you applied, did you apply the extension before their I-94 expired or after I-94 expired?
Before the I-94 expired.
Did you got the receipt notices identifying that you applied extension before the I-94 expired?
Yes.
So they have from January of 2020 to June of 2020, you applied extension before June of 2020 and you got the receipt notices for that. And then you didn't pursue it. You didn't went to the biometrics and all those things. If you have all the evidences, their passport visa is not invalid because you applied for extension. The way you told me was that you applied extension until December of 2020 and then they stayed until January of 2021. But if you've applied extension, they came from January to June and you applied for extension, they left in July. If you have the receipt notices of the extensions that have been filed, they don't need to go for stamping. When they come into United States, make sure that they have a documentation that they filed the proper extension, they left the country within the extension period of time. You have the documentation, you keep it,
Yeah.
you give it to them. They don't need to go for stamping again.
Okay. That's good news. Okay. Thank you.
Thank you.
Thanks a lot. Yeah. Bye.
Thank you.
Thank you, sir. Thank you so much for calling, Andy. All right, folks, I know we have a lot of people in the waiting room as well as on the live chat, but unfortunately, as always, we are all out of time today. Rahul Garu, thank you so much, Andy, for being on this show today and for answering all the questions and for bringing in more interactions. We really love that, Andy. Thank you.
Thank you, Nitya Garu. Thank you, guys.
And to all our viewers, have a great week. Recover from your Thanksgiving meals, and then we'll see you same time, same place next week then. Until then, have a great week. Bye.